Good morning, Your Honor. Terrence Daniels, plaintiff and pro per.
Good morning, Mr. Daniels. All right, so, Mr. Daniels, you didn't file any written opposition to the demurrer, is that right?
Actually, I have. And speaking of that demurrer, Your Honor, that demurrer and motions attached to it was ruled on and vacated on 5/30 of 2023. So I'm kind of confused as to why that was allowed to be resubmitted and to unnecessarily delay my trial the day of an FSC. So I didn't feel the need to respond to it twice, but while we're speaking of that demurrer, like I said, I had an FSC scheduled for 6/5 and a trial scheduled for 6/20, all of which was unnecessarily and improperly delayed without me receiving notice until the day I stepped into this courtroom. So as a result, I'm asking that this court impose sanctions pursuant to CCP 128.5 for unnecessarily delay of proceedings on behalf of the opposing party.
Anything defendant's counsel wants to offer with regard to that?
Yeah, that's completely out of place. There's no procedure. There's no written document asking for sanctions. There's been no appearance by Mr. Daniels in the last year since this case was filed. Our demurrer states that he was supposed to have dismissed this case pursuant to the stipulation in the unlawful detainer action. He didn't do it. He didn't do that. He's continuing not to do that. I don't understand what his purpose is in appearing for this hearing today, other than to try to revive a claim that has absolutely no facts to justify a cause of action, given that stipulation in the unlawful detainer action, which the court can take judicial notice of. I'm really at a loss for words as to why he is here, why he is pursuing this case, especially in light of his non-appearance over the last year, his failure to file a case management conference statement, and his failure to confer with me over the instant demurrer. The earlier demurrer to which he refers to last year was essentially mooted since he filed a First Amendment complaint, which flies in the face of his agreement stipulated to in the unlawful detainer case. So there are no grounds to sue. The complaint fails to state a cause of action. In light of the stipulated judgment in the unlawful detainer case, has promised to dismiss this case with prejudice, which he has failed to do today. If anyone is owed anything, it's the plaintiffs, or it's the defense, my clients, for having to answer this frivolous lawsuit.
Right, Mr. Daniels, that is correct in terms of the demurrer that's set for today. There was no opposition filed. I'm looking back there because I think you're referring to your opposition to the previous demurrer when this case was in a different department. Because right after that amended complaint was filed, this case was reassigned from Judge Linfield to my department. So all dates get vacated when the case gets transferred from one department to another, and we have to reschedule things. So if there's anything that you want to argue with regard to the substance of the demurrer argues that this case should be dismissed because there was a settlement in the parallel unlawful detainer case, and so that's really the issue that I have to decide is whether that settlement, stipulated judgment, means that this case should be dismissed according to the terms of that agreement.
Absolutely, and I'm happy to respond to that, Your Honor. As far as any stipulated judgment from an unlawful detainer case, in my initial response to that demurrer, which stated the same extrinsic evidence that was being disguised as judicial notice, the only thing that's worth judicially noticing or taking judicial notice of is the fact that that stipulated judgment that the plaintiff was representing a different party is referencing it's worth judicially noting how flawed, fraudulent, and unethical that stipulated judgment was. For one, that unlawful detainer court did not have the jurisdiction to order me to to dismiss anything with prejudice. Number two, the merits of my case are based off implied warranty of habitability. CCP, or California Civil Code of Procedure, as well as Supreme Court ruling in Knight v. Haltzheimer, says that implied warranty of habitability cannot be waived. It may not be waived by stipulation, Your Honor. It may not be waived by action, meaning if I was to move out or to file a case, and it may not be waived by inaction. So this demurrer thing, again, as I would like to reaffirm, is merely a delay tactics by the defendants. Moreover, that stipulated judgment, Your Honor, has a totally different entity as a party, which proves that it was fraud. That entity has proven no right to ownership of the property in question. I had zero contract, unlike what was noted in the recent demurrer. They, you could call it false information or disinformation, or maybe the attorney didn't have a chance to read over all the documents, but that party never had a right to claim possession of that unit. But the Los Angeles County Superior Court, more specifically the Stanley Moss Court, went on ahead and endorsed that fictitious, fraudulent stipulated judgment, and then had the nerve to enforce that stipulated judgment at gunpoint to my face, defrauding me of my home and effectively strong-arm robbing me of my possessions. So I would like to ask the court to excuse my appearance. I don't have much left, and I'm sleeping on the side of the road in a car because of the fraudulent actions of the plaintiff and the Los Angeles County Superior Court. That's my response.
Thank you. So, I'll give defendant's counsel the last word since it's your demurrer. Is there anything you want to respond to there?
Yeah, Your Honor, Mr. Daniels signed the stipulation, we were there, he agreed to it, even attempted to dismiss this case, but he filled out the paperwork improperly and got rejected by the clerk, and he didn't remedy the defects. Even though we asked, instead what he did was he called off and filed the First Amendment complaint. I don't know why. Other than that, he's got no law to support this habitability non-waiver issue. There's nothing to support that, there's no facts. We have a stipulated judgment with an agreement in there to dismiss this case. There's no equivocation on that. It's undisputed, it's indisputable. This action should be dismissed with prejudice. Thank you, Your Honor.
Well, let me ask one question. That the stipulated judgment in the unlawful detainer case does not have MJW Investments as the signatory. Is that a distinction without difference? Because you're essentially using, in this instance, you're relying on a settlement agreement that was between different parties, but the obligation under that was to dismiss this case. So I'm just, if you're not a third-party beneficiary and you're not the same party, literally not sure if there's a standing issue or not.
Yeah, it is a distinction without substance for two reasons. One is that the action that was filed, or this action was filed as Terrence Daniels versus 233 South Lafayette Park. South Lafayette Park is the owner, MJW Investments is the manager, the property manager. And the second reason is his First Amendment complaint names MJW Investments. And it's under the same case number as this case here. If he wanted to add MJW Investments, then there would have been other language put into that stipulation to cover the liability and the cause of action that Mr. Daniels alleged against MJW Investments. And that would have been covered as well. Since it wasn't covered, and he didn't imply or state any intention of filing against MJW Investments, that wasn't covered in the stipulation, and he should not now, after 2 years, be able to assert any cause of action in this complaint that should have been dismissed back in 2022.
Your Honor, may I respond to that, because that is not accurate information.
I'm going to take this under submission and issue a ruling on the demurrer.
Your Honor, that's
because we're in trial and we've got a motion and some other matters we got to take care of it before the jury gets here at 10 o'clock.
I understand that, sir, Your Honor, but that is not accurate information. The initial proceedings were against MJW Investments, and then MJW Investment fraudulently created this fictitious entity, and then as in retaliation started to try to defraud me of my rights and unethically get me to sign something for another party. MJW Investments was always the initial defendant. 223 South Lafayette Park Place, once I realized they were going around as a fictitious entity claiming ownership of that property, they became liable because, as I stated, and as the Supreme Court of California stated in 2003, warranty of habitability cannot be waived. And that's, again, Knight v. Haltzheimer. I'd recommend that Mr. Idavai look up that case and stop saying it's unsubstantiated and there is no facts or law to support that, for there is.
Thanks. I'll take this under submission.